Well, hello everyone. This is Tom Cicenti. I'm the police chief over at Furman University. I just want to welcome you all as everybody's joining in and getting started to this webinar with Taser International. We're doing this on behalf of the National Association of Campus Safety Administrators who organized this webinar for us. Before we get started, for those of you who are in our region or close by to us, we just wanted to point out that that association, the National Association of Campus Safety Administrators, along with IACLEA, the International Association of Campus Law Enforcement Administrators, will be holding a regional conference here at Furman. It's 3 days, $150 for a 3-day conference, which is a great price. The first day is going to be specifically focused on diversity challenges. It's a certification course at a command staff level, so it's a great command staff course for certification. We'll also have Chief Dave Perry from FSU coming in that first day to talk about the FSU shooting. Beyond that, day 2, we're going to have D. Stafford and Associates coming in to do a morning presentation on lessons learned from the Department of Education. We'll have a breakout session on body cameras. The Secret Service is doing a session on the candidates are coming. And we're just going to have a bunch of great breakout sessions. And then day 3 will be certification courses and tactical communication and active shooter response and things like that. So feel free to hop on the website down there below, nacsa.us, to get more information about that. So with that said, let me introduce our presenter today. It's going to be Michael Brave. He's the he's the International and National Litigation Counsel for Taser International, and we're excited to have him. Michael's been fabulous to work with as we lead up to this presentation. When I called and asked, he didn't hesitate, wanted to present on this. He knows what he's talking about with his case. He has a very full bio that I will send out to everyone. I could sit here and read it to you, but after speaking with Michael for a couple of days now, it's clear that he will have no problem telling you about it as well. But he has a full background, really solid background, and I think he's going to be able to answer a lot of our questions. I'm going to pull up his slide presentation here while he introduces himself to you and welcomes the group. Michael.
Good afternoon, all. Presentation, introduction, I'm not sure what all you want. The bottom line is for Taser, I am International Litigation Counsel. I'm also legal advisor to the Taser Training Board, legal advisor to the Taser Scientific and Medical Advisory Board, legal advisor to the chair of the Legal Advisory Board, and I'm also the person most knowledgeable for the organization, which means that if someone wants to come in and depose or have someone testify at trial, someone at Taser, I'm the lucky individual that gets that. Now, as far a little bit about use of force, I've been teaching constitutional limitations on use of force for over 2.5 decades. I've been an expert in over 200 cases. I teach this all the time, including at the Secret Service Academy in Maryland. So I've been doing this for a while. I am still a police officer part-time. I try not to work if I can avoid it. And I also am certified to teach or have been certified to teach every weapon available to law enforcement. Is that enough of an introduction to get us started?
I loved it. I loved it.
Okay, on this case, I'm going to give you just a very brief intro to a couple things to put this into perspective, and then I'm going to go through excruciating detail, and I apologize for that. But as I was putting together these PowerPoint slides from a table that I put together in early January after the case came out, I realized there's a lot of things on there that you might be interested in. The one thing I want to point out with all of this stuff is, yes, times they are a-changing, meaning I truly believe U.S. law enforcement will be adopting the United Nations framework on law enforcement use of force, which is only use that minimum amount of force necessary to accomplish lawful objectives. It hasn't happened yet, but that's the direction we're heading, and don't fool yourselves. The U.S. was a signatory to that back in the 90s under President Clinton, and we're moving in that direction. Bottom line is that society and a lot of special interest groups and politicians do not want officers to use force except as a last resort, and they are making decisions and they are moving in that direction. So just to get us started, you'll notice 311 slides there. I added this to my normal slide deck, meaning we're not going to get to anywhere near that. I just left them in there in case there was a question. So first, to put this into perspective, this is not the law, but this is a paradigm that I use to teach officers with, because I found that as you may know, officers and chiefs don't understand the constitutional limitations on use of force. Don't kid yourself, and I can go into great detail on that, but the bottom line is they don't, nor do most attorneys. So, but I found that this little chart, whereas if I ask the officer, look, why are you using force? Are you using it for defensive purposes because the person's an immediate threat? Are you using it to capture them because they're fleeing? Are you using it for restraint purposes, such as to overcome turtling? Are you using it to gain compliance? In other words, the only reason you're using force is to get the person to comply with you, meaning they're not an immediate threat, they're not a flight risk. That's compliance force, and that is the Armstrong case, by the way, is compliance. They really don't touch on defensive force or capture force or restraint force. It is compliance force. And the last one is distraction force. If you don't know what that one means, most people don't. There's only a few cases on it. That is usually where a person is in hard restraints, handcuffs, and they're trying to transition him to soft restraints to provide medical attention, and they end up using force because the person is too strong and they have to distract his mind long enough to get him into soft restraints. But that's what distraction force is. Now, frequency of use of force. A lot of people don't get this out of encounters with law enforcement. Force is only used 1.4% of the time, and even arrests, only 2.1% of those arrests have weapons. Meaning, force, even in the United States, even though you'd think because of the media, the TV, etc., it happens all the time, it really doesn't. And that is important to remember because when you think about how much force an officer has been trained to use, they really don't use it often enough in order to get good at it, in order to make their optimal decisions. And we can go into that in more detail later. Okay. Oh, this was supposed to pop up in segments. It didn't. But this gives you an idea. In the last year for which these numbers are available, there were 39.9 million public contacts. There were 776,000 force used or threatened. There were 447,000 believed force was excessive. And there were 61,249 annual force complaints. Now, what's important is look over to the right side. For approximately every 600 to 1,000 uses of force, there will be a temporal death. Not necessarily caused by, but temporal. And also for jails, this one floors a lot of people. For every 700 people that enter a jail and they're booked in, one person will die. Those are the numbers. Here are the numbers if you want them a different way. For every 100,000 contacts with law enforcement, there'll be a death. Every 13,000 arrests, there'll be a death. Every 600 to 1,000 uses of force, there'll be a death. And for 700 jail detentions, there'll be a death. Now, here's why I'm bringing this up. These things occur, on average, less than once per officer's career. But it's not just officers, it's everybody involved. That means officers, supervisors, trainers, investigators, medical examiners, forensic pathologists, prosecutors, law enforcement executives, decision makers, etc. These things happen less than once per officer career. The reason I bring this up is because then how good can anyone be on this topic? As an example, if you look at a Taser temporal death, all of these people happen less than once per career. Therefore, how good are they? I depose medical examiners and forensic pathologists on a very regular basis. They don't know this stuff, and when it happens less than once per career, I can't expect them to put in 2,000 hours and buy 100 medical scientific papers, do the reading, and get past the learning curve to understand it. That's the reality we're faced with. The problem is, it's the officers that are the brunt of this. If a medical examiner blames the officer for the tool that was used or for a technique that was used or the officers were there and therefore it becomes a homicide, we all know how that goes downhill from there. And we also know how law enforcement executives and prosecutors make decisions based upon that, and it usually isn't straightened out for a couple of years later. Okay, here's the case we're here about. The state of Armstrong, out of the North Carolina, it's out of the Fourth Circuit. The decision came down on January 11, 2016. Two things I want to point out. Number one, the principles in the Armstrong case are not new, meaning people have been pushing these for best practices for several years now. The Civil Rights Division of DOJ, Police Executive Research Forum, and also so-called best practices. And these principles coming from Civil Rights Division and PERF also are in the present Taser program, and they have been for 4 or 5 years, in their training program and the smart use guidelines. So therefore, this is not new. Now listen closely to this, because here's what the problem is. As you may know, since Ferguson, August of 2013, I believe, there have been numerous task forces, the White House Task Force, the Ohio Governor's Task Force, the PERF Task Force, etc., that have all come down with their, quote, best practices to stop officers from using force. The problem is this. None of them clearly state what the constitutional threshold is to use force versus the should force of what they want officers to do. So let me put this another way. A chief was praising the PERF guidelines and the White House Task Force, et cetera, and I asked the chief, I said, real simply, Chief, okay, but here's the question to you. Where is the shall, meaning officers, you shall obey this threshold, because if you don't, you can be criminally prosecuted, civilly sued, disciplined, or terminated, versus the should, here's what we would like you to consider and do if time and circumstances permit, which there is no discipline, there is no criminal prosecution, there is no civil lawsuit for. And all of these things don't have that. And it's causing huge problems out there when you start asking people how much force can be used on someone. The first question you have to ask, what's the threshold? And what are the consequences for using more force than that threshold allows? Simple example, put this into perspective. And I don't know if anybody out there watches football, or you did recently up to the Super Bowl, but the point is, if football was run the same way our standards of force are, there would be rebellions every Sunday. Oh, is that a field goal? Well, no, we're not sure, because we have to look at it from the vantage point of the other side, and then it may be or may not be based upon the 10 yards to or from. Oh, no, you may or may not be able to look at the video. No, we're going to, in other words, when you start looking at it and comparing the two, there are actual rules with consequences that most of us know. In football, there are not those exact same clear rules in use of force today that most people know. And it's sad, and they're getting murkier and worse because of these groups that are pushing their special interest best practices of use of force, and they're confusing those with what the thresholds are that actually have consequences. Okay. Now, the Taser training, version 20, came out January 1 of this year. But these slides with this information have been in there for 4 or 5 years now. And again, these came from the Civil Rights Division of GOJ. But here it is, smart use considerations. If person is not an immediate threat or flight risk, that's the key. In other words, you're using it for a reason other than immediate threat or flight risk. Then, do not immediately resort to a taser without first attempting to use negotiation, commands, or physical skills. That's one of the things that Armstrong says. 2, avoid using CEW on person who is actually or perceived to be mentally ill. That, too, is in the Armstrong case. And then avoid using CEW on elevated risk population member unless necessary and justifiable. And again, remember, this goes back to immediate threat or flight risk. Those are the keys. And the second one is, do not use pain compliance if circumstances dictate that pain is reasonably foreseeable and effective, usually due to drug, alcohol, or mental illness caused elevation of pain tolerance. So what this means is, if you're using force to gain compliance, then you're not using it because there's an immediate threat or flight risk, then think about whether or not the force you're going to use is likely to work. If it's not likely to work, then don't do it. Those are the main factors of the Armstrong case, and now let's go through some of those. Here's the brief history. The incident date was April 23rd, 2011. The district court judge did grant summary judgment to the officers, and then this decision by the Fourth Circuit in a 2-3 decision, 2 judges to 1, came down on January 11, 2006. Law enforcement did ask for an en banc appeal, in other words, to have all the judges of the Fourth Circuit look at this. Taser also sent in an amicus brief asking to also take part in that, or at least put forth their input. And also the FOP also sent forth a request to be an amicus as well. All of that was denied, and this case became the law 48 hours ago on February 16th. bear in mind this is the law in the Fourth Circuit, which includes Virginia, West Virginia, Maryland, North Carolina, and South Carolina. Since February 16th, this is the law. However, I'm sure there are going to be other judges in other circuits that are also going to follow this. So whether you live in those few states or not, you better pay attention to this, because this is where it's going, and this is how some judges are going to rule. Very brief synopsis. Do not use serious injury force. Now, that is one of the terms that this court used for the first time that isn't found in any other federal case. I did a full Westlaw search of every federal case on Westlaw, and the term serious injury force is only in this case. What's interesting is the pundits that have written on this have said, oh yeah, that's the Taser. No, it's not. It's basically any force that causes pain or injury. In other words, when you read the whole case, it's a Taser device, CEW, conduct electrical weapon in any mode, pepper spray, punch, grounding, tackling, or wrestling maneuver. Those are the ones that are included in the Armstrong case. But the whole point here is serious injury force is anything that causes pain or injury. Therefore, if you have a 5-year-old child that is going to go play soccer or football, bear in mind, according to this court, they could sustain serious injury force, pain, and or injury because of taking part in that physical activity. So, do not use serious injury force to gain compliance from a person who is exhibit only minimally risky physical resistance. That is another term that is not found in any other federal case, only this one. Who is not a serious threat or posing some risk of immediate danger to officers or others, not just himself. That's what this case is saying. So when you boil it down, do not use pain or injurious force, which is any serious injury force, if the person is not immediate threat, not a flight risk, and you're only doing it to gain compliance. Secondly, what the case also points out in excruciating detail is to be very cautious of what resistance is. In other words, I'm going to give you some examples, as the court does, but you can't automatically assume that minimally risky physical resistance allows you to use serious injury force. As an example, if you grab my arm and all I do is yank it away, under present law, under most jurisdictions, that's active resistance. That's not good enough here to use serious injury force. Okay? Go to the next one. Armstrong decision also focused on when person is not a serious risk or risk of immediate danger to officers or others, not just himself, then we're a mentally ill person who is physically resisting or presenting minimal risk physical resistance, then less force is justified than a criminal arrest, Fourth Amendment seizure. Translation, if I'm seizing this person under the Fourth Amendment because of mental illness, but not because of a crime, you're allowed to use less force. Next, officers should take their time and not rush to use force. Court included that CEW force began in 30 seconds. What really happened was officers had interacted with this man for approximately 20 minutes while they were waiting for the doctor to sign the order to take him into custody. As soon as the order was signed and the officers were notified, that's when the officers, according to this court, were not patient enough and they began using force after only 30 seconds. So what the court here is saying is, again, if this is minimally risky behavior, mental illness, and you're only using force for compliance purposes, and the person is not a threat to anyone other than himself, then slow down, take your time, and use as much time as is reasonable. And of course, that's going to be up in the air for upper grabs, but be sure to do that. Do not use force that the officers do not reasonably believe will work to mitigate need for the force. Again, this goes to, since you have time to think about this, think about whether or not the force you're using is likely to work. If it's not likely to work, then don't use it. And in this case, they were talking a Taser device in drive-stun mode, which of course is only for pain compliance, And since this person was in a mental health crisis, he was bipolar schizophrenic, he was 4 to 5 days off his meds, then the drive stun is not likely to work to cause a pain to get him to comply. Since it's not likely to work to cause him to comply, then don't choose that as your force option. That's what they're saying. So he was bipolar, paranoid schizophrenic. On April 23rd, he'd been off his medication for several days, which was unpredictable and erratic state. Bear in mind, it's not in this slide deck, but people who are paranoid schizophrenic, who are off their meds several days, have an increased mortality rate of 4 to 5 times the normal person. By the time Officer Shepard arrived at the scene, Armstrong was engaged in self-destructive behavior. He was eating grass, dandelions, and gauze, and burning his arms and tongue with cigarettes. Now, bear in mind, yes, he was hurting himself, but by the time the officers used force, the moment the force occurred, he was no longer doing that. Therefore, the court would not allow that to be taken into consideration. Police obtained an involuntary commitment order to bring Armstrong back to the hospital. Armstrong did not return to the hospital, despite his sister's pleas to stop resisting authorities. She was there, as well as 3 police officers and 2 hospital security staff. Armstrong was a strong man and weighed 260 pounds. Before the officers ultimately detained Armstrong, they did not have an opportunity to frisk him for weapons. So what happened is, once the officers told him they were taking him in, he sat down on the ground, wrapped his arms around its stop sign post, hugging it, and refused to let go. That's what he did. It was because of that resistance that the officers warned him to let go, or they were going to use the taser. He did not let go. The officers then discharged the taser in drive stun mode up to 5 times. And he still wouldn't let go. Then it took 5 people pulling and tugging on him for several minutes to get him to let go. The court basically said the pulling and tugging, in other words, the hands on him to pull him off, that was objectively reasonable, but serious injury force that causes pain or potential injury was not. Officers had observed Armstrong wandering into traffic with little regard for avoiding the passing cars, and the seizure took place only a few feet from the active roadway. Officers applied graduated levels of force, first verbal commands and then a soft hands approach, prior to Officer Gatling use of taser device. And remember, they looked at this in the light most favorable to plaintiff. And since the taser had 5 trigger pulls on it, therefore, in the light most favorable to plaintiff were 5 trigger pulls, 5 applications, and drive stun. Armstrong tried to kick the officers as they put handcuffs on his legs. Tom, I'm going to go through 2 slides more of the basic facts, and then we're going to break for a minute if you want to catch up on any questions. And I have not been able to read the questions, and that'll give us a break before we get deeper into the case.
Sure,
so
Mike.
basic facts.
Direct questions
so,
yet.
We don't? Okay. All right. So, by the way, I did see somebody wanted this PowerPoint. I'm more than happy to give it to anybody that wants it. Secondly, I've got the actual case. Third, I also have a table that includes almost everything on this outline that I can also send you that puts all this into perspective, and I'm more than happy to give that to anybody that wants it. Okay, so the basic facts: Armstrong, 5 drive stun in 2 minutes. 5'11", 262 pounds, mentally ill, off his psych meds for 5 days. He was being seized for his own protection, not because he was a danger to officers and others. Note, in the order of protection, the doctor specifically checked he was a danger to himself, not to others. Was seated on the ground, hugging a post to ensure his immobility, surrounded by 3 officers and 2 hospital security guards, and had failed to submit to lawful seizure for only 30 seconds. Court emphasized the time. A reasonable officer would have perceived a static stalemate with few, if any, exigencies, not an immediate danger, so severe that officer must beget the exact harm the seizure was intended to avoid. Also, that Armstrong had already left the hospital and was acting strangely while the officers waited for the commitment order to be finalized does not change this calculus. If merely acting strangely in such a circumstance served as a green light to use CEW use, it would then be the rule rather than the exception that when law enforcement officials encounter the mentally ill, that cannot be by the time officers chose to inflict force, any threat had sunk to its nadir. Armstrong had immobilized himself, ceased chewing on inedible substances, and ceased burning himself. Use of force designed to cause excruciating pain, that comes from the Kavanaugh decision, in these circumstances is an unreasonably disproportionate response. Key points. If no exigency, including immediate safety risk, slow down and consider minimal option solutions. If no exigency exists that is sufficiently dangerous to justify potentially injurious force, slow down the situation in response and consider options as the circumstances of the incident allow. These next two are key because these are different from the vast majority of other cases out there. Physical resistance does not equate to a risk of immediate danger. Physical resistance, including minimally risky physical resistance, does not equate to, is not risk of immediate danger. Mentally ill subject is not necessarily a safety risk. So in the eyes of these two judges and this court and this decision and this holding, just because the person's mentally ill, that doesn't mean that equates to a safety risk to the officers and others. Avoid using force option that is not reasonably likely to cure the immediate safety risk, meaning since you've got time to think about it, you have to think it will work before you're going to apply it. If subject is not a risk of immediate danger, do not use serious injury force, including conduct electrical weapon, punch, throw to the ground, tackling, wrestling maneuver, or pepper spray. Do not use CEW or other injurious force on a person who is not a serious threat or posing some risk of immediate danger to officers and others, not just himself. Then document immediate safety risks, risk of danger, resistance, force used, and avoid embellishment. Here's why I say that. If anybody has followed the Bland case down in Texas, the state trooper who's now been terminated and is now being criminally prosecuted, he put it in his affidavit report that he believed she was being combative. Well, the prosecutors took that to the grand jury. The grand jury disagreed that she was combative, and they indicted that officer for lying in his report. So therefore, that's why I added that in there. Do not let your officers embellish a report, because if the powers that be wish to prosecute you or cause problems, we now have some examples of that occurring. And if you don't know what I'm talking about, Bland was the African American female who was in her car, who was being belligerent, wouldn't stop smoking, etc. The officer threatened to, quote, light her up, brought her out of the car, took her to the ground, took her to jail, and she committed suicide. I think it was 3 days later. And that state trooper is lost his job, and he's being criminally prosecuted because of the phraseology he used in his report of combative, when the grand jury said they found that she wasn't being combative, so he's being criminally prosecuted. Now, the court did say legitimate purposes for CEW include protecting officers, protecting arrestee, or preventing arrestee's escape. They didn't spend a lot of time embellishing that, but they did say that. Now, where a lot of people missed here is they compared the CEW, the Taser device, to other traditional tools of compliance. And that's why I wanted to bring this up, because a lot of people are saying, oh my God, the use of a Taser is being so restricted. No, the use of any force that is likely to cause pain or injury is being affected. Therefore, if you're going to modify your policy based upon this case, and if you basically live in the states of the Fourth Circuit, you'd better, it goes in your general use of force policy with any force that causes pain or injury, not just your Taser policy. So traditional tools of compliance, pepper spray, punch, throw to the ground, wrestling maneuver, tackling. And this conclusion that CEW use is unreasonable force in response to resistance that does not raise a risk of immediate danger is consistent with our treatment of police officers' more traditional tools of compliance. So, serious injury force is excessive if the person is only showing physical resistance or minimally risky physical resistance and is not a risk of immediate danger or a serious threat. Thus, if it's only physical resistance and minimally risky physical resistance, then you cannot use serious injurious force. If there are a risk of immediate danger or a serious threat, not just to himself, then you can use more force. This is correct especially if the person is mentally ill rather than a criminal arrest. Physical resistance or minimally risky physical resistance does not equate to, is not risk of immediate danger. Selected important points: force must be proportional to threat. Physical resistance does not equate to, is not the same as risk of immediate danger. Mental illness is to be considered differently than criminal activity. CEW is serious injury force, just like pepper spray, punch, throw to the ground, grounding, wrestling maneuver, as would canine, baton, beanbag, significant pain, joint lock, pain compliance, etc. Do not use serious injury force where there is physical resistance without risk of immediate danger to others. Only use serious injury force to thwart risk of immediate danger to others, not just himself. Use force that officer reasonably believes will mitigate immediate danger, meaning, as an example, if an officer does not believe that pain compliance, drive stun will mitigate danger and gain compliance, then don't use it. Proportionality. Officer's force must be proportional. To properly consider the reasonableness of the force employed, we must view it in full context with an eye toward the proportionality of the force in light of all the circumstances. Officer's force is only proportional if subject's resistance raised a risk of immediate danger that outweighs the Graham versus Connor factors mitigating against harming the subject. And I assume everybody's familiar with Graham versus Connor, U.S. Supreme Court, 1989. Physical resistance does not equate to, is not synonymous with, risk of immediate danger. Resistance does not equate with an objective threat to safety entitling officer to escalate force. CEW, just like pepper spray, punch, throw to the ground, grounding, wrestling, maneuver, tackling, is serious injury force. Officer may only use serious injury force when objectively reasonable officer would conclude that circumstances present a risk of immediate danger that could be mitigated by the force selected to be used. CEWs are proportional force only when deployed in response to a situation in which a reasonable officer would perceive some immediate danger that could be mitigated by using the CEW. That is likely the key phrase right there. CEW use is unreasonable, excessive force in response to resistance that does not raise a risk of immediate danger. Armstrong had not committed a crime, and officers had no probable cause to effect a criminal arrest. Officers were on notice of two facts that bear on the question of whether officers had reason to believe Armstrong was dangerous. Second and third Graham factors, whether Armstrong threatened the safety of others and resisted seizure, justify some limited use of force. Officers had seen Armstrong wandering into traffic with little regard for avoiding the passing cars, and the seizure took place only a few feet from an active roadway. Armstrong fled from the hospital earlier that day, although he did not go far. Under such circumstances, officers' concerns that Armstrong may try to flee into the street to avoid being returned to the hospital, thereby endangering himself and individuals in passing cars, were objectively reasonable. A degree of force, not serious injurious force, was consequently justified. But that justified degree of force is the degree reasonably calculated to prevent Armstrong's flight. When officers decided to begin using force, Armstrong, who stood 5'11" and weighed 262 pounds, was stationary, seated, clinging to a post, refusing to move, and was outnumbered and surrounded by 3 police officers, 2 security guards, and his sister was also present. The degree of force necessary to prevent an individual who is affirmatively refusing to move from fleeing is obviously quite limited. Armstrong was the subject of an involuntary commitment order, thus was necessarily considered mentally ill. Armstrong's mental health was thus one of the facts and circumstances that a reasonable officer on the scene would ascertain, a fact that officers must account for when deciding when and how to use force. It cannot be forgotten that the police were confronting an individual whom they knew to be mentally ill. The diminished capacity of an unarmed detainee must be taken into account when assessing the amount of force exerted. The problem posed and thus tactics to be employed against an unarmed, emotionally distraught individual who is creating a disturbance or resisting arrest are ordinarily different from those involved in law enforcement efforts to subdue an armed and dangerous criminal who has recently committed a serious offense. The use of force that may be justified by the government's interest in seizing a mentally ill person, therefore, differs both in degree and in kind from the use of force that would be justified against a person who has committed a crime or who poses the threat to the community. Mental illness, of course, describes a broad spectrum of conditions and does not dictate the same police response in all situations. But, in some circumstances at least, it means that increasing the use of force may exacerbate the situation. And that comes from the Durolay versus Rutherford case out of the Ninth Circuit. Accordingly, the use of officers and others trained in the art of counseling is ordinarily advisable where feasible and may provide the best means of ending a crisis. And even when this ideal course is not feasible, officers who encounter an unarmed and minimally threatening individual who is exhibiting conspicuous signs that he is mentally unstable must de-escalate the situation and adjust the application of force downward. I did
Mike, we have a few questions. Whenever you want to get to a break, let me know.
I think this is the end of mental. Hold on. There's two more mental illness. Then let's do them. Danger to himself, not a danger to others. The second relevant factor that officers could glean from Armstrong's commitment order is that the doctor determined him to be a danger to himself, not a danger to others. Okay, let's go ahead and break there. Go for it, Tom.
All right. So one question is. Does this mean that the release, would this also apply to like the release of a police canine in situations such as like a house search, or just in general when the person is not compliant?
Well, those are two different things. In other words, let's go with the house search first. The question would be, why are you doing the house search? Meaning, if you're doing a house search of a residence where you believe someone has broken in to burglarize it, or you don't know why the person is there, then the canine is not an issue. If the house search is to attempt to get control of someone who is believed to be mentally unstable but has not threatened anyone in any way, then you're going to have a problem if the canine is trained in find and bite.
Okay. Can you define the difference between immediate danger and immediate threat versus immediate?
Actually, I can't, and the reason why is because this court mixes them up and uses them interchangeably. Here's the best way I can explain it. Well, let us say this exact same guy had stood on his feet, and the moment the officer said, "You're going with us," he bladed himself off and made a fist. Would that give a reasonable officer sufficient articulable indication that he's going to physically resist and somebody's going to get hurt? In my opinion, that answer is yes. And at that point, the taser would be an ideal force option to be used under those circumstances. The whole point here is that he was never. This court stated, again, looking at the facts in the light most favorable to plaintiff, that he was never a danger to anyone but himself. And when the force was used, he was sitting on the ground, hugging the pole, refusing to let go. So he was an immediate threat. He wasn't a flight risk. And basically, they had to overcome that passive resistance. The court basically said you can use force that doesn't cause pain or injury, but you cannot use force that does cause pain or injury. Now, obviously, I disagree with this court and these judges, but my opinion doesn't count. But this is now the law in the Fourth Circuit, and I see other judges are going to follow it in other circuits.
So a follow-up to that someone had was, and you addressed it a little bit. So if the person's simply fleeing from us and not blading with us and not, making fists or anything like that, would that change? Or they're simply fleeing from us when we're trying to place them into custody?
Okay, let's talk about fleeing here for a minute. Number one, too many people talk about fleeing only applying to taser devices. And if somebody wants the language for this policy, I'm happy to provide it. I don't put it into my sample taser policy. I put it in my general force policy. And the reason why is because using force on someone fleeing, which means momentum of the individual and also taking him to the surface and also the fight that's likely to ensue, in my mind, it applies to intentionally grounding the person, as well as tackling the person, and as well as using a taser device on the person to stop their fleeing. So in other words, the first thing on fleeing is put it where it belongs and put it in your general force policy, not just your taser policy. Number two, fleeing. Now it depends on what is the degree of immediate risk. In other words, let us say this guy had jumped up and ran towards traffic. Under those circumstances, would they have been justified in either intentionally grounding, tackling, or using the taser device on the surface that they were on? And in my opinion, yes, because that made him immediately a danger to not just himself, but also the people on the roadway, the officers, and others. So then it would be okay. Now, if he was fleeing back towards the hospital, then I would suggest I would personally try to hold back on using the force of intentionally grounding, tackling, etc., if that was the situation. So if the person is perceived to be an immediate threat because of his flight, then the question is, why are you taking him into custody? Here they're taking him into custody for mental health commitment. So if he's not fleeing in such a way that is any kind of a threat, you're going to be on really shaky ground. If he's fleeing in such a way that he is an immediate threat or he's causing immediacy of threat, such as towards traffic, then it's not going to be an issue.
Okay, I have two more for you that we have. Would this decision have changed in your opinion, or is it something we should consider if we did not know the mental health history and we were taking him into custody for something like trespassing for holding on to that bar? Would that have changed things if we didn't know the mental health history?
My opinion is yes, but let me explain why. If you look at the Matos and Brown case, it's in the Matos decision, but it's the Brown. It's not the Matos decision. If you look at that case out of Seattle, the equation is if you're going to use serious injury force, meaning pain or causing injury, to get someone to comply, the equation you have to use is, again, be real clear here. The only reason you're using the force is to get compliance. They're not immediate threat or flight risk. Then you must believe that the force will work. In other words, you do not believe that they're incapable of complying, or et cetera, because of mental illness, distress, et cetera. Two, you give them a warning of the impending use of force. Number two, you give them a chance to think about it, and then you use it. Now, before you can use force again, you have to give them a chance to collect themselves, compose themselves, get over the pain, and then you start the equation over, warn them, give them a chance to think about it, give them a chance to comply before you can use force again. And the best example I can give of this, where I work, it's a real small town. My nearest backup is normally 20 minutes away. What happens if I've got, and this actually happened, a Greco-Roman college champion who I got him in handcuffs because he let me, but then he refused to get them back in my patrol car. He was drunk. He was being foolish. But basically at that point, is he mental health? Nope. Do I have any reason to believe that the pain will not cause him to comply? Nope. So therefore, sir, either get in the back of my patrol car or I'm going to use the taser on you. I'm not getting in. Sir, either get in, I'm going to use the taser. I'm not getting in. Use the taser. Now, if he doesn't get in, then I have to go start the equation again, give him a chance to collect himself, get over the pain, recompose himself, and then warn again. But that's the equation you have to go through. Now, bear in mind one other thing. The other cases that have decided this issue is, do you have to be softer, gentler, and more compassionate with a mental health person versus a non-mental health person? Other cases have decided this, such as the Bryant case out of the Ninth Circuit from Coronado Island. They said there are not two standards. Well, this court clearly says there is. The other thing is, hopefully, the law enforcement defendants in this case are presently considering an appeal to the U.S. Supreme Court. to try to get a decision once and for all to help officers on this decision, which is exactly how much force can I use on somebody to gain compliance, and do I have to take mental health into consideration if I have knowledge of it. Hopefully the U.S. Supreme Court will take this and give us that decision. But of course, personally, I'm concerned about it now that Scalia has passed away. That means who knows what the composition of the court is going to be by the time they would hear this case.
Okay, and then we did have a question. How is this decision going to affect correctional facilities and inmates already in custody and seized?
Okay, first, as far as correctional facilities, you've got it. There are two different. All right. Number one, is the person in the facility convicted while incarcerated or not? The reason why is if at the moment the force is used, the person has been convicted and is still incarcerated, then the standard is under the Eighth Amendment: do not use cruel and unusual punishment in your actions towards that person. That this decision is not going to affect that at all. The other thing is, and I don't know how much everybody on this call knows about this, but about 6 months ago, and I'd have to look up the exact date if anybody wants it, the U.S. Supreme Court decided the Kingsley case. Prior to Kingsley, a pretrial detainee in a correctional setting, the officer's use of force cannot shock the conscience or be malicious and sadistic. That was the standard. Kingsley changed all of that. This is the U.S. Supreme Court dictate, which basically says for people that are pretrial detainees in correctional settings, the standard went from shock the conscience, don't be malicious and sadistic, to objective reasonableness. Therefore, since that is the case, I can see plaintiffs arguing this case, which is based on objective reasonableness, also under the U.S. Supreme Court case of Kingsley objective reasonableness when force is used on a pretrial detainee. Therefore, look at the basics of what this case is saying. This case is real simple. Number one, the person is not immediate threat or flight risk. Okay, got it. Now decide if the person, if the force you're thinking about using has a good probability of working, and then decide what are you trying to accomplish, and then decide if time and circumstances permit how you want to apply force to make this work. To look at this another way, if there are exigencies that say you got to use force now in order to protect someone or to prevent immediate threat, then it's not an issue. If you're using force only to gain compliance, and if the person is in mental health crisis, and if you don't think pain is going to work on this person because of the crisis they are in, then I'd suggest you follow this case and think twice about what you're going to do as far as use of force in order to get compliance on this. And again, this goes to, are there exigencies involved here or are there not? In other words, if he's over there banging his head against the wall, he's a threat to himself, but is brief pain to get him under control less injurious than what can happen to him by his banging his head against the wall? And that's the balancing test that you have to look at.
Okay, and then just one more follow-up to the example you used of the arrestee. The question was, in that example, if he refuses to get in the car and he is handcuffed, he's not necessarily a threat to you, just refusing to get in the car. Is a taser justified?
Okay, first there's three cases directly on this point where the courts have said, yes, it is. But here's the question to you. What else can you do to get him into the car that would be a lower intrusive force than the taser? I mean, that's the question. I mean, you're not going to use a gun. You're not going to use a baton. You're not going to use pepper spray, the gift that keeps on giving. If you're going to use any kind of a pain compliance hold, such as a joint lock pain or mandibular pain, etc., then you might as well use the taser. So the question is there any other available option to you to get this guy into the car that has a probability of working? And that's the decision you have to go on. In other words, let's say I got 4 more officers coming. Terrific. Tell him to get in the car. He stands there and looks at you. Now what do? You get four guys wrestling this guy in the back of a patrol car. We all know what kind of problems can happen there, including for the officers. So, again, give them plenty of opportunity to comply. Give them a warning of what's going to happen, and don't use it unless you have to. But also in your report, be sure you explain why other lesser quantums of force you believed were ineffective or you tried them and were ineffective. And if you're not familiar with the term quantum of force, what that means is what are the foreseeable consequences to this individual of the use of force option I have chosen under the circumstances of its use? I mean, real quick, I don't know if anybody out there on this call still uses continuum, but as an example, can my voice be deadly force? And quantum of force, again, is what are the foreseeable consequences of the force option I have chosen under the circumstances of its use. Here's your example. I'm the officer who's responding to a jumper on the top of a 10-story building. He's standing on the edge. He's saying, I'm going to jump any moment. I look at my watch, and I look 5 minutes before I'm done. Anything I can do to talk you out of this? No. Boo! And he jumps. My voice is now deadly force. So when you look at this, don't try to lump all uses of force into specific categories. Look at it a quantum of force, and what is the objective of what you're trying to accomplish. And again, the objective you're trying to accomplish is, why am I using this force? What am I attempting to do with it? The quantum of force is, what are the foreseeable consequences of the force option I have chosen under the circumstances of its use?
Okay, that's all we have for now if you want to keep on.
Okay. I already did that one. The first gram immediate threat to others factor weighs against imposition of force. The government's interest in seizing Armstrong was to prevent a mentally ill man from harming himself, not others. The justification for the seizure, therefore, does not vindicate any degree of force that risks substantial harm to the subject. And bear in mind, the court is defining substantial harm to the subject as serious injury force as anything that causes pain. We could use some force, but not serious injury force. We are cognizant that courts ought not undercut the necessary element of judgment inherent in a constable's attempt to control a volatile chain of events. That's the Brown case out of the Eighth Circuit. And we certainly do not suggest that officers had a constitutional duty to stand idly by and hope that Armstrong would change his mind and return to the hospital on his own accord. But the facts of this case make clear that our ruling does not hamper officers' ability to do their jobs. Tasing Armstrong did not force him to succumb to officers' seizure. He actually increased his resistance in response. When officers stopped tasing and enlisted the hospital security guards to help pull Armstrong off the post, however, the group removed Armstrong and placed him in restraints, even though he kept kicking and resisting. So if you're thinking, how am I supposed to know if my force is going to work on this guy before I use it? I agree with you. This is what the court said. The court basically said, well, since the taser didn't work, it was excessive, and since 5 people pulling on him worked, then therefore that was okay. And I have the same concern over that as you do, but again, this is what these two judges said. Had officers limited themselves to permissible uses of force, such as physically pulling Armstrong off of the post, that's 5 people, by the way, 3 police and 2 security. When seizing Armstrong, they would have had every tool needed to control and resolve the situation at their disposal. And I wish I could take a poll and see how many people are laughing at this point, but this is what the court said. Pepper spray. Court's conclusion that the CEW use is unreasonable force in response to resistance that does not raise a risk of immediate danger is consistent with the treatment officer's more traditional uses of tools of compliance, such as pepper spray. Pepper spray causes closing of the eyes through swelling of the eyelids, immediate respiratory inflammation, and immediate burning sensations. Pepper spray is excessive force when used on arrestee's wife, who is sprinting toward officers to assist her husband upon seeing him placed in handcuffs. So the officers thought the wife's running full bore toward their detainee was basis to arrest the wife for disorderly conduct and obstruction of a law enforcement officer in the performance of his duties, court rejected any notion that such behavior justified the application of pepper spray. Again, officers have got to do the best job they can at delineating between, is this person an immediate threat to me or someone else, or are they simply minimally risky physical resistance? Because it was difficult to imagine that unarmed wife as a threat to the officers or the public, the officers' irresponsible use of pepper spray twice from close range was indeed excessive. Punch, throw to ground, grounding, wrestling maneuver. Court's conclusion that CEW use is unreasonable force in response to resistance that does not raise a risk of immediate danger is consistent with treatment of officers' more traditional tools of compliance. Officer who punched arrestee threw him to the ground and used a wrestling maneuver on him because when there was no real evidence that a relatively passive, mentally delayed man was a danger to the larger trained police officer, despite this resistance, the arrestee posed no threat to the officer or anyone else. Punching this second one, because she took only a step back off of the small stoop in front of the door and pulled her arm away during attempted handcuffing was excessive force. Nominal resistance does not justify officers' use of force where a reasonable officer at the scene would not have any reason to believe that arrestee was a potentially dangerous individual or was at all inclined to cause the officer any harm. Again, all of these are consistent with what this court found. CEW was not permissible when used against unrestrained person who was only actively resisting, not a risk of immediate danger or serious safety threat. Questions whether arrestee 1 has been restrained and 2 is complying with police directives are relevant to any inquiry into the extent to which the arrestee posed a continuing threat to the officer's safety. It's the Myers case, it's out of Maryland. And it's also, I think it's a Fourth Circuit case as well. They are not dispositive. A rule limiting CEW use to situations involving a proportional safety threat does not countenance use in situations where an unrestrained arrestee, though resistant, presents no serious safety threat. And again, this is just not CEW. This is anything that causes pain or potential injury. Defining the situation force. Again, this is for compliance. This is not when they're an immediate threat, not when they're a flight risk. Warning of force was given to a person exhibiting nonviolent resistance to desist, and force was discontinued before that person was secured. Immediate danger is key. Immediate danger is a key distinction. Tasing arrestees ceased being proportional force when officer continued to use CEW after arrestee did not pose a continuing threat to the officer's safety. Nonviolent or minimally risky physical resistance. Nonviolent physical resistance does not necessarily create a continuing threat to officer safety. Here's the examples that the court gave of minimally resistance. Refusing to enter an out-of-state officer's police car until a local officer is summoned is not a sufficient threat to the arresting officer to justify physically striking arrestee. Arrestee pulling her arm away when officer attempting to grab her without explanation. Arrestee yanking his arm away from officer does not justify being tackled. CEW use can be excessive force when used in response to non-violent resistance. Subject refusing to release his arms for handcuffing, for example, is not evidence suggesting that he violently resisted the officer's attempts to handcuff him. This is the Cyrus case out of Wisconsin, out of the Seventh Circuit, and again, this was a mentally ill man who broke into a home that was under construction and refused officers' commands, ended up on the ground and being, according to plaintiffs, drive-stunned 12 times. Such a refusal does not justify use of a CEW when subject is unarmed and there is little risk he could access a weapon. Subject actively resisted when she refuses to get out of her car when instructed to do so and stiffens her body and clutches her steering wheel to frustrate the officer's efforts to remove her from the car. But when she also does not evade arrest by flight and no other exigent circumstances exist at the time, a reasonable fact finder could conclude that officers' use of a CEW in drive stun was unreasonable and therefore constitutionally excessive. And that's the Matos case discussing Brooks versus Seattle. That was the 7-month pregnant female in her car, who was accused of speeding in a school zone, and she refused to get out of the car because she refused to sign her license. She grabbed onto the steering wheel, refused to let go, and she braced her feet, and they drive stunned her. And the court basically gave us the equation there as to when we can use force for non-compliant individuals, at least in the Ninth Circuit. And they also said that 37 seconds after use of force, before you use it again, to allow them to get over the pain, recompose themselves, gather themselves, give them another warning, give them another chance to comply, was not long enough. So it had to be longer than that. It has to be a reasonable amount of time. CEW use can be excessive. Refusal to terminate phone call after police ordered arrestee to do so does not justify use of CEW, even though officer was concerned that arrestee could use glass tumblers near her feet as weapons or could kick the officer. This is the Brown versus Golden Valley case out of Minnesota, and this was the wife sitting in the passenger side of the car when her husband was arrested for DWI, and she was on the phone to 911 yelling and screaming about how bad the officers were and how they were harming her husband. Exigencies. Courts tied permissible CEW use to situations that present some exigency that is sufficiently dangerous to justify the force. Analysis factors. Parsing CEW use based on the level of resistance the arrestee was offering and the danger that resistance posed to the officers when each shock was administered. Each use of force must be justified by continuing danger, threat, or resistance. Here are a few examples of when force was excessive. Officer repeatedly shocks a person who is no longer armed, has been brought to the ground, has been restrained physically by several officers, and no longer is actively resisting arrest. Use of CEW after they have been secured. Punching or pepper spraying subjects in response to minimal, nonviolent resistance. It is excessive to use a CEW to control a target without having any reason to believe that a lesser amount of force or a verbal command could not exact compliance. Painful, injurious, serious inflictions of force, like the use of a CEW in any mode, do not become reasonable simply because officers have authorization to arrest a subject who is unrestrained. CEW use against individual exhibiting unusual behavior and shouting gibberish and expletives, who is unarmed, stationary, and facing away from an officer at a distance of 15 to 25 feet. That's the McPherson case out of the Ninth Circuit. CEW use when misdemeanor was not violent and did not try to flee but resisted being handcuffed. It was unlawful to use a CEW on nonviolent suspected misdemeanant who was not fleeing or resisting arrest, who posed little to no threat to anyone's safety, and whose only noncompliance with the officer's commands was to disobey 2 orders to end her phone call to a 911 operator. And again, in all these cases, remember, these are on motions for summary judgment, which means the court is looking at all of these incidents in the light most favorable to the plaintiffs. Therefore, I'm not saying, or no one else is saying, that these are actually the facts of the case. These are the facts in the light most helpful to plaintiffs. Okay. That's the end. I hope you're not bored out of your minds of the Armstrong case, but it all goes down to if the person is not immediate threat and not a flight risk, then think twice about using any force that either causes pain or has a potential to cause injury.
Mike, the only question we have holding right now, and I think you addressed it, but I'll ask you again just to make sure, was how can an officer determine what any one person's individual pain threshold would be, and whether it would be effective prior to inflicting it?
Here's the best way I can explain that. Okay. I don't know if you've seen the case, but it's the Buckley versus Haddock case. I've got the video on that. It's also on YouTube. And in that case, the 23-year-old male who was being put under arrest, who refused to get off the ground, and the taser was used several times, he was bawling his eyeballs out. He was talking gibberish, and he would not get off the ground. When you've got someone such as that, or this person was obviously in mental health crisis, etc., those people, pain alone is not foreseeable to work. And therefore, any pain that you use on them is not likely to accomplish your lawful objectives. So now, again, go back to if the officers reasonably perceive this person to be an immediate threat, then it would have been okay to use this, quote, serious injurious force, including pain, to try to make it work. But the question is, what is going on with this person that would indicate to me whether or not pain would likely have an effect? If they're having a complete emotional meltdown, like Buckley versus Haddock, where they're crying their eyeballs out, and it's obvious that pain is not going to work. In this case, where the guy is eating dandelions and putting cigarettes on his arm and hugging the post, and they know he's mentally ill, pain is not going to work on that individual. When you've got those kind of parameters, another way to look at this is police officers are chasing a guy, ordering him to stop, and the officers either tackle him, intentionally ground him, or use a taser on him and bring him to the ground. And it gets him under control. Then they learned the guy was deaf. In other words, he could not obey their orders to stop because he could not hear them. Since the officers learned about that after the force was used, it would be objectively reasonable. But if the officers knew while they were yelling at him to stop that he was deaf, then the use of force, because of their foreknowledge and the foreseeability that their force is not going to be effective or their orders are not going to be heeded, then it would be objectively unreasonable. But that's the best way I can explain it. I hate to say it this way, but it's one of those things that you know it when you see it. It's just officers have to be aware of it and be looking for it in order to see it and then accurately place it in their reports after the incident is over.
All right, this is an opinion one, I think, but if you kind of addressed it a little bit in a couple cases, but if you could circle back around, you tell someone that they're under arrest, they pull away from you after you attempt to handcuff and take off running. In that scenario, what do we tell our officers is acceptable use of force?
I hate to tell you this, but it all depends on what you're arresting them for and why they are running. In other words, if I'm in a Walgreens and this 16-year-old kid just stole a pack of gum, and that's when he jerks away from takes off running, you better not ground him, you better not tackle him, you better not use a taser on him, especially on a hard surface. On the other hand, if I'm responding to a domestic and this person had just knifed a person and then thrown the knife and they're covered with blood, and then they do the same action, then it's not an issue. Your use of force is going to be objectively reasonable. So it basically depends on why you're doing what you're doing. So the way I would look at it is this. If their continued flight, you can state could be an immediate threat because of what they've done or the knowledge you have, you're probably okay. If it is a person that was involved in a series of physical harm events, and then in other words, if they get away, they're gone because you're not even going to be able to identify them, then you're going to be on really solid ground to take them to the ground and stop them, because that's the only way you're going to catch them. If it's a very minor event and it's not physical harm and they're not immediate threat, and if they get away because of surveillance cameras or whatever, you can catch them later, then you better not be dropping them head first under momentum to a hard surface.
All right. Well, I think I can probably sum it up, sum the webinar up with the law enforcement opinion of that just sucks, Mike. But hopefully we get this to the Supreme Court and we can kind of change the opinion on this. But
give me about 60 seconds. Here's my problem with all of this. If you look at the history of why our constitutional standards of care are there, in other words, they go all the way back to the Magna Carta, 1215 England, and the purpose was do not intentionally abuse your government-endowed authority. That's what it is supposed to be. And as a matter of fact, the U.S. Supreme Court case from 1989 said that. The problem is we are actually, as I said when we started this, we are moving from don't intentionally abuse your authority to minimum force necessary to accomplish lawful objectives. Don't kid yourself. That's where we're headed, and I believe we're going to be there within 10 years. And as much as I despise it, I think that's where we're going to be headed. And I personally think it's wrong, but of course I have no more control over it than anybody else on this call.
All right. Last question for you. You think Taser is going to be published in any type of written policy guidelines or assistance?
Well, two things. Number one, Taser never has and will not publish policy guidelines, etc. They don't do it because Taser's in 107 countries and they're in every state out of 195, and because of that, Taser cannot publish. Back about 12, 14 years ago, there was an incident where an officer drew her firearm as opposed to her Taser, shot the guy in the back of the seat, and Taser published policy/guidelines on where to carry your Taser and how. There was a huge uproar in the law enforcement community, which basically said, Taser, butt out. We will take care of policy and guidance. So therefore, Taser has not since and does not write policy, etc. However, I have my little company on the side. It's called Law LAAW International LLC, short for Liability Assessment Awareness International LLC, and I've had it since 1989. I do have several sample, not model, policies with verbiage that I'm happy to share with anybody. You can take them, use them, consider them at your heart's content, and I'm more than happy to forward them. Secondly, I was asked to address this neurocognitive. Do you want me to talk about that at all, or do you want to skip that?
Yeah. I'd forgotten about that, and I was just thinking about bringing that up. For those of you, it doesn't really apply necessarily to this specific case, but one of the pre-questions we got earlier in the week was about a case involving false confessions, for lack of a better word, after Taser use. And so we thought, while we have Mike on the phone, it might be a good opportunity for us to ask about that case and let him just talk about it for a minute.
Okay, very briefly, it's not a case. This was a study funded by the National Institute of Justice that was done by Kane and White, and it was published a couple of months ago now. And in this study, they took a bunch of college kids and they gave them some neurocognitive tests. In other words, remember these 10 words, repeat this 10 words. In other words, cognitive tests to test your memory, your thinking, etc. And then they did various things. They hit them with a Taser, and they also had them hit a heavy bag for 30 seconds in some instances. And what came out of that was they believed that the neurocognitive tests that Kane and White did with these college students, some of the college students did more poor after the Taser use. Not all, but some. Whereas some also did better after the Taser use. So what happened is Kane basically put out there, what can it hurt to wait 60 minutes to give Miranda? In other words, his quote is, it doesn't cost anything to wait and to let somebody fully recover after being tased before the police start to ask questions. Kane said it just levels the playing field. I completely disagree with that. First of all, there was another paper that I was a co-author on from 2013, which basically looked at several different use of force scenarios. It looked at hitting a heavy bag for 45 seconds as though you were being attacked. There was a dog scenario. There was a pepper spray, et cetera. And the neurocognitive detriments, in other words, your ability to remember sequences of words and other neurocognitive tests, decreased with all of those stressors, not just the Taser. Got it? So in other words, Kane and White basically only looked at the Taser and said, well, it might cause a neurocognitive deficit, which could be significant enough in order to wait for 60 seconds or 60 minutes before you give Miranda. So therefore, there should be a bright line rule not to give Miranda for 60 minutes. Okay. Here's what I would like everybody on this call to think about. Imagine the ramification if officers were required to wait 60 minutes after every encounter involving a stressed person, exertion, emotional stress, distress, agitation, alcohol, drugs, mental impairment and crisis, etc., to attempt to acquire any form of consent or waiver, including but not limited to Miranda rights, performance of field sobriety tests, giving of statements, consent to search, or other action requiring voluntary, knowing, or intelligent waiver or consent. Here's my point here. Kane and White, who only looked at the Taser, are saying that, well, there was some changes, detriments from the Taser, so therefore what can it hurt to wait 60 minutes to give Miranda? My point is, since the Dawes study, which I was a co-author on, said that all of these stressors that they tested showed the same detriments, then take anyone you deal with, alcohol, drugs, emotional distress, etc., and aren't every one of those going to be a detriment to their cognitive ability? In other words, if you take a drunk you just stopped for DWI, how well do you think they do on these neurocognitive tests? Same with drugs. Same with somebody during a domestic crisis. Same with somebody in emotional distress. And if they're saying that you have to wait and prove that they are over their emotional crisis before you can ask for consent, think about what that means. Sir, may I? Oh, I'm sorry. I see you're under distress. Did you? Yeah, I just had a fight with my spouse. Oh, well, I better wait 60 minutes before I ask consent to search your car. Think about that. Alcohol. So, therefore, I have to wait till all the alcohol influence is gone before I can ask them to whether or not they'll consent to a field sobriety test. Ask them. In other words, think about this, and this is what Kane and White said. And bear in mind, this is one study funded by the National Institute of Justice, and they didn't say you have to do this. What they said is that they need to do more research. Translation, they need more money from the government so they can research this more so they can get to the bottom of the answer of the issue. Now, two of the things that Taser did put out is the Kane and White conclusions rely on an unrealistic comparison scenario, emphasizes a few measures and ignores others, does not fairly recognize that the punching bag group, which again is unrealistic, also had decrements in performance and may have had a slower recovery in some measures, over-relies on non-objective self-reporting, and uses small statistical differences on some limited cognitive batteries to generalize to a statement about understanding consequences, in that case Miranda. 2, we feel that the Dawes et al. Study better addresses the issue and that all uses of force, as well as all stressors, fear of arrest, etc., can affect some areas of neurocognition as part of a general stress response, but that this does not necessarily extrapolate to an ability to understand consequences and the Miranda warning. Drs. Kane and White's current study compared a 5-second taser exposure to 30 seconds of punching a heavy bag and found a statistically, not necessarily important, greater decrement in performance in a few of the tested cognitive measures. In the taser group, compared to the punching bag group, in fact, the taser group showed improvements in some of the measures immediately after the exposure. And in fact, there were measures in which the taser had a faster recovery than the punching bag group. The conclusions of the authors overemphasizes a few measures, does not fairly recognize that the punching bag group also had decrements in performance and may have had a slower recovery in some measures, and over-relies on non-objective self-reporting. The authors, Kane and White, make a giant leap by generalizing these findings to the broader question of a subject understanding a Miranda warning. In their first figure, they present the average number of words recalled on testing. First, the control group, which had no intervention, had a drop. Second, the range between the groups was 22 to 26 remembered words. It is very difficult to take a few word score differences and generalize that to the understanding of the Miranda warning. Furthermore, 30 seconds of punching a heavy bag, which is highly effort dependent, causes no pain or stress over the exertion itself. In a study by Dawes et al., this was published in 2013, previously published, several use of force scenarios were compared to taser exposure. These scenarios included a fight scenario, sprinting, pepper spray, and a canine search and bite scenario. In this study, there was no statistical difference between the groups, and the authors concluded that the decrement in cognitive testing post-scenario represented a generalized stress response. In the Dawes et al. Paper, the first scenario involved 45 seconds of fighting with an opponent, creating a much more realistic scenario than college students punching a heavy bag. The Kane and White conclusions rely on an unrealistic comparison scenario, emphasizes a few measures, and ignores others. Does not fairly recognize that the punching bag, which again is unrealistic, also had decrements in performance and may have had a slower recovery in some measures. Over-relies on non-objective self-reporting and uses small statistical differences on some limited cognitive batteries to generalize to a statement about understanding consequences. We feel the Dawes et al. Study better addresses the issue and that all responses to resistance, as well as other stressors, fear of arrest, can affect some areas of neurocognition as part of a general stress response, but that this does not necessarily extrapolate to ability to understand the consequences of Miranda. And again, my whole point here is it's not just Miranda. What about any time you need consent or waiver to be knowingly given from any individual? If you need that, then if you follow their guidelines, you're going to wait 60 minutes for that consent, and they don't see as to how that can be a problem. Well, I see lots of problems when every time an officer needs consent or waiver, spelled wrong by the way, but when they see that they have to wait 60 minutes anytime the person is stressed or under the influence of alcohol, drugs, mental impairment, or in crisis.
Excellent, thank you. We did have one pop up and from right here in Greenville. Going back to the taser use, can you speak a little bit more, Mike, about any issues specific to pre-trial detainees and the use of force, and kind of elaborate a little bit on that?
Yeah, okay. And I can also send out the Kingsley case to anybody that wants it. But what happened was the U.S. Supreme Court decided Kingsley, and I'd have to look up the date, but I'm thinking it was October of last year. And what happened was, prior to that decision, use of force on a pretrial detainee, in order for it to be excessive under the 14th Amendment due process clause, you had to shock the conscience or be malicious and sadistic in your use of force. And what the U.S. Supreme Court did was they wiped out that shock the conscience, malicious, sadistic standard and replaced it with objective reasonableness. Therefore, once you seize someone under the Fourth Amendment, all the way through until they're convicted, including when they're in your detention facility but not yet convicted, all of that use of force is now covered under the objective reasonableness standard. And the Fourth Amendment standard and the 14th Amendment standard is basically the same. And they basically said that that is the new standard. We are no longer going to recognize shock the conscience, malicious, sadistic. It is now objective reasonableness for pretrial detainees. And it is a huge difference. Now let me give you one more to think about here. If you're involved in a vehicle pursuit, you guys don't do vehicle, well, maybe you do. If you're involved in a vehicle pursuit, if you do not seize the person, meaning you do not intentionally touch them or ram them, or they're not seized during the pursuit, then the standard was 14th Amendment, due process clause, as long as your pursuit does not shock the conscience, is not willful and sadistic, there will be no federal liability under the 14th Amendment. When the U.S. Supreme Court redefined the 14th Amendment standard from shock the conscience, malicious, sadistic to objective reasonableness, that means that also applies to pursuits where there is no seizure. I personally believe this is going to cost law enforcement several $1 billion over the next 5 to 10 years while they learn this, but that's what the U.S. Supreme Court did to us when they changed the threshold of use of force standard for pretrial detainees, because they didn't just change for pretrial detainees. They changed the standard under the 14th Amendment. Remember, under the Fourth Amendment, a seizure use of force, the standard has been objective reasonableness since 1985, Tennessee versus Garner, or 1989, U.S. Graham versus Connor. Up until Kingsley, just late last year, the standard under the 14th Amendment due process clause was shock the conscience, don't be malicious, sadistic. So therefore, in pursuits, there was never, since Lewis versus Sacramento, I think it was 1986, there's been virtually no federal constitutional liability for pursuits. Well, now there will be, because those pursuits are going to be under the same standard as the 14th Amendment due process clause of pretrial detainees, which used to be shock the conscience and now is objective reasonableness. If I gave anybody a headache, I apologize. Take some Excedrin, get a glass of wine or a beer, and call me in the morning.
Right on, Mike. Well, hey, listen, that wraps it up for us. We will publish these, or we'll send out a link to these PowerPoints, if that's okay with you, Mike. It sounds like it is, along with some contact information in case you want to get a hold of Mike directly, especially if you want some help writing policies. It sounds like he might be able to provide some assistance with that. Thank you so much for your time, man. An hour and a half with Taser's litigator. That doesn't come often. We really appreciate you taking the time out for us in campus law enforcement or South Carolina law enforcement and doing that for us. Thank you, Mike.
My pleasure. Just one last thing. Bear in mind, this is my full slide deck that I cut and paste from all the time. So don't get freaked out if you see something in there you disagree with. Just bear in mind that there it is. Knock yourselves out.
Thanks, man. Have a great day.
Take care. Bye.